With me is retired Chief Justice Deborah Koritz and Fran Hessler, who's an attorney in Westfield. Welcome. Okay, so please introduce yourselves.
Hi, good morning. My name is Emily Polinsky.
My name is Daniel Young. My name is Andrew Wu.
Hi, I'm Ali Ignatiak.
I'm Aviv Pavich, and this is our advisor, Alan Brodman.
Good morning.
Good morning. Okay, I'm going to read the question, and then when I complete it, I will tell you that you may begin. How has the Constitution been changed to further the ideals contained in the Declaration of Independence? In Federalist 51, James Madison claimed that the government must be structured and designed so that the three constitutional branches in their relationships will have the ability to keep each other in their proper places. What is judicial review, and how does it try to keep the other branches in, quote, their proper places? In writing Marbury versus Madison in 1803, what were the major arguments Chief Justice Marshall gave to justify judicial review? Why has judicial review remained controversial to the present day? You may begin.
Judicial review is the power of the courts to declare unconstitutional acts void and unenforceable. It makes the judiciary the final arbiter of the meaning of the Constitution. Judicial review ensures that the other branches follow rule of law and allows the Constitution, as noted by Justice Thurgood Marshall, to meet the challenges of the changing society. Judicial review keeps the other branches in their proper places by interpreting the Constitution, declaring other branches' acts in violation of the Constitution null and void, providing a means for people to check the other branches' actions, ensuring rule of law, and limiting tyranny of the majority. The court limited the executive by rejecting President Nixon's assertion of executive privilege referencing a congressional subpoena in U.S. v. Nixon. Professor Richard Brisbane, Jr. notes that judicial review is the single most important post-1787 addition to checks and balances.
In Marbury v. Madison, Chief Justice Marshall began the process of justifying judicial review by noting that the judicial power of the United States is extended to all cases arising under the Constitution. This affirms the courts as responsible for addressing cases of a constitutional nature. He goes on to note that constitutions form the fundamental and paramount law of the nation, and consequently, an act of the legislature repugnant to the Constitution is void. This sets a foundation for the court's recognition of judicial review, as it affirms that laws that violate the Constitution cannot be empowered and are essentially null and void.
Marshall then argues that the judiciary is the appropriate venue for review of the Constitution and the determination of its meaning. He noted that it is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret the rule. If two laws conflict with each other, the courts must decide on the operation of each. He describes this as the very essence of judicial duty. Having identified that the Constitution is paramount and that a court's job is to determine the meaning of the law, Marshall then concludes that the particular phraseology of the Constitution confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to a constitution is void.
Judicial review has remained controversial because it is not in the Constitution, it is anti-democratic and anti-majoritarian, it is not representative, it ignores other branches' capacity to define the Constitution, there are limited checks and balances on it, as well as its small size, life terms, perceived political and ideological differences, and its addressing of controversial issues. Judicial review is not expressly provided for in the Constitution, and therefore, according to Professor Paul Kuhn, lacks proper legitimacy. Professor Keith Whittington notes, judges exercising the power of judicial review may appear anti-democratic because they obstruct the will of the electoral majority and because they appear to be acting as lawmakers. Critics also cite the fact that justices are neither directly elected by the people nor held to definite terms, which, as Senator John Cornyn notes, makes judges unaccountable to the public.
Judicial review is also controversial due to the perception of political and ideological differences on the court, which infers that decisions are being made based on these viewpoints as opposed to the Constitution. This is reflected in the court's abortion decisions, as well as in Bush versus Gore, which determined the outcome of the contested 2000 presidential election. Finally, judicial review is controversial because it addresses controversial issues. Professor Kermit Roosevelt III says, cases among the court's most controversial deal with abortion, campaign finance regulation, and the death penalty.
Okay, thank you. Now, going to ask follow-up questions. Justice?
You've explained to us a little bit about the origins of judicial review in our system, Mulberry and other cases. And you've given us views about whether it's an appropriate power, whether it is a power that we should be concerned about that goes too far, that's anti-democratic perhaps. Could you now tell us what position you would take individually on whether this is an appropriate power or not, and what arguments you think are the best arguments to either defend the power or say that the power is has unbalanced government, giving the court that much power?
I believe it is beautiful that the judiciary is the final arbiter of the meaning of the Constitution, and the beauty of this is even though they are not directly elected, the president or the Congress or the state has the option to not enforce that if they feel the judiciary has made the incorrect decision. Now, while I do not agree with, for example, President Jackson ignoring the decision in Worcester v. Georgia, I do think that it is great that the judicial branch makes strong recommendations that are almost always followed.
In a similar vein, I believe that judicial review is an inherent ability of the courts. It has neither influence over sword nor purse, but merely judgment. But this is its role in government, that while Congress will make the law, the court's role is to determine the constitutionality of the law, and the president is in charge of enforcing it. However, I do have some concerns over the limits of judicial review, as it is not an enumerated power of the Supreme Court. One of the concerns is that there's no limit to whether one branch might be able to usurp the power of another, as seen in maybe Bush v. Gore.
Although it is an anti-democratic and anti-majoritarian system, the beauty of the system is that the executive gets to decide whether or not they want to enforce it. And this is good because it allows for, as a final arbiter of the Constitution, it allows for an outside party removed from the political viewpoints of the legislature in order to better interpret our Constitution.
I would have to disagree. I'll be the one to disagree here. And Thomas Jefferson, when he was reviewing judicial review, he made a very strong case against it, in that he said that it should fall to the people when they convene, either in Congress or 2/3 of the state, i.e. by an amendment, to change how the Constitution works. And in Thomas Jefferson's words, by giving all this power to the judiciary, he said essentially the Constitution is an act of suicide, and that basically the judiciary, in the hands of the judiciary, the Constitution would become the mere thing of wax to be twisted and shaped into whichever form they wish. I believe Thomas Jefferson may have gone a little bit too extreme on his position, but on the other hand, there are very strong arguments against judicial review, as Justice Gibson made in Aiken v. Rao. Basically that each branch should be able to determine the constitutionality of their own actions. And the Supreme Court cannot simply assume the powers of the legislative or the executive simply because it conflicts with the Constitution, because it is not enumerated in the Constitution.
I believe that judicial review fits perfectly in our system of checks and balances because it ensures that one branch is not overpowering another branch, and the power of judicial review ensures that the courts can rule unconstitutional laws or laws unconstitutional. And, well, for example, in U.S. v. Windsor, the Supreme Court ruled that the Defense of Marriage Act was unconstitutional because it violated the Due Process Clause in the Fifth Amendment.
Next question.
This question is a follow-up to what I think part of your answer. And so, should the executive and legislative branches, as well as the judiciary, have the power to declare what the Constitution means, why or why not? And I believe that you indicated that you thought it should. And if you could, and everybody else, just expand on that. And in doing so, comment on whether anybody would ever say that their own actions were unconstitutional.
Yes, well, whenever when any government official takes office, they take an oath to uphold the Constitution. And so I believe that the very essence of our system is that when the legislature makes an act or the executive acts, they have to interpret their own action as being constitutional or unconstitutional. And while we are putting that in their hands to determine, they are also answerable to the people.
Right. Last night, President Obama said that he would veto any laws that not only harmed business, but that were unconstitutional. So in that State of the Union address, President Obama was voicing something that we often do not get to publicly see. The reason behind a particular branch not voting something that was unconstitutional. We don't get to see those drafts publicly often.
Okay, thank you. That's time. I think your responses were interesting, thoughtful. Jefferson really say all that?
Yes. Those are correct Thomas Jefferson. He did not approve of Judicial Reviewer John Marshall.
No, he didn't.
Cousinly feud.
That was a question of power, and who was going to exercise the power. In a way, that was a political response. Let me compliment you on your presentation. It was excellent. I really liked the way you all worked together to respond and tried to complement one another in your responses, and to contribute even when someone else was talking on the subject, to add something to it. You did it very well. I thought your initial presentation was excellent. It covered a lot of ground. It's hard to do this when you have 5 people trying to work within very tight time constraints, and you did it very, very well. Thank you.
Yeah, I agree. I like the give and take among you, and the fact that you try to bring out the different points of view. I agree. So I think that was really, really good. And if you go on, I'd say, in just explore always further what the weaknesses are in each other's arguments, so that you could think, if you get the follow-up question, which we don't have time for here, what the response, would be. In all cases, you should always think about, one of the aspects of judicial review, which wasn't talked about very much, which is how you protect the rights of minorities. And so that has to also enter into the answers that you get.
Thank you very much.